The Beaches against Rhodin and Mr. Gooch for the appellant. I should say petition. Is this an appeal or
petition, Your Honor? Writ for cert. Petitioner. Your Honors, my name is Earl Gooch with Smith, Halsey, and Busey in Jacksonville. I represent the petitioner. I'd like to reserve 6 minutes for rebuttal. Your Honors, the trial court below departed from the essential requirements of law by accepting as sufficient, legally sufficient, the affidavit of a nurse, corroborating affidavit, when the nurse was not legally competent to corroborate medical causation, failed to disclose that her opinions had previously been disqualified by a court of law, and was not legally, did not meet the legal requirements that she be duly and regularly engaged in the practice of her profession. For that reason, we ask that the court issue a writ quashing the trial court's denial and remand with instructions that Baptist Medical Center of the Beaches be dismissed from the pending action. Your Honors, in this matter, burden of proof is critical. This court wrote in Oken v. Williams several months ago that it is the claimant's burden. It is the claimant's burden to demonstrate by facts, not conclusions, that their experts' qualifications meet the statutory requirements.
But Oken's a very limited context. It just construes subsection A of the statute dealing with specialists. How does it apply over to this case where you're actually challenging the expert witness qualifications, at least on your causation? You're not saying that a nurse can't testify. You're saying, well, in this case, she can't testify. How does Oken help us with that?
Well, Your Honor, first of all, because it speaks to the burden. It is the claimant's burden to demonstrate that the expert meets the qualifications necessary to corroborate a pre-suit affidavit. This court held in Archer v. Maddox that it's not just necessary to corroborate negligence, but that negligence resulted in injury.
So what are they supposed to do? They file the CV, they tell what she's done in her life, and she's this, that, and the other, PhD nurse or whatever. What else are they supposed to do?
Your Honor, there was no facts offered to suggest that Ms. Byrne, who is a nurse, a perioperative nurse, a nurse whose knowledge concerns the immediate preoperative, intraoperative, and postoperative period, that she has any special education, training, or experience in the field of cause and effect of neurologic injury, diagnosis, whether earlier diagnosis or whether earlier awareness of symptoms.
She's a nurse. Florida law requires her to be an expert in diagnosis. That's what the Nursing Practice Statute says.
Actually, Your Honor, what the Nursing Practice Act says is that medical diagnosis and treatment fall within the purview of a special advanced nurse, but not within the purview of a registered nurse. In fact, nurses are by law prohibited in Florida from diagnosing conditions. Moreover, the Supreme Court in Chavez just last year held that it's not enough to be generally knowledgeable. You have to have special knowledge in the discrete area that is the subject of the testimony. And there was a failure by the claimant. Claimant's failure to meet their burden to demonstrate competence.
I would say I don't want to harp on this, but I really do want to. It seems to me like Oken we can take out there whether you like it or don't like it, and I know you like it.
Yes, Your Honor.
You can take Oken and say, okay, hard call, this guy does not fit under sub-A because you're suing a specialist. By golly, you got to have a similar specialist. But beyond that, it almost seems in reading your petition that what the hospital is suggesting here is that we approve some sort of extensive trial-like voir dire of every expert, and then if you say that expert's not qualified, the trial court has to reject the pre-suit affidavit. Isn't that what you're really suggesting?
No, Your Honor. If there had been any evidence offered, if there had been any facts to suggest that this nurse had any education, training, or experience in the diagnosis, treatment of neurologic injury, paralysis, then the discussion would be over. The claimant's burden may be low, but it's not non-existent. And Your Honor, with respect to the second failure by the trial court, the second departure from the essential requirements of law, Section 766-204 requires that any witness disclose, quote, any opinion which has been disqualified. Now, Your Honors, The Third District reminded us just a few months ago in the case of Variety Children's Hospital versus Boyce that pre-suit medical malpractice statutes must be given their plain meaning. Respondent contends that it's not enough that the opinion be disqualified, but that the expert who gives the opinion must be disqualified. And that is absolutely not what the Florida statute says. What Section 766-204 says is that you must disclose whether any opinion, specifically, Your Honor, the Garcia Court, the Texas Appellate Court, held that Ms. Burns' affidavit was not sufficient to corroborate a claim and disqualified it, struck it, excluded it. It doesn't matter how
The Texas court said it wasn't relevant to get over the threshold because it addressed the negligent behavior of persons who were not parties to the lawsuit.
Your Honor, the appellate court dismissed the underlying case against the doctor because it found that the nurse's affidavit did not satisfy the statutory requirements.
No question about that, but let's be real careful about what we say the Texas appellate court did. And it's my impression, could be wrong, often am, that the Texas appellate court said, hey, plaintiff, you paid your money, you took your chances. You got an affidavit on the behavior of these people thinking that it would flow over onto the behavior, negligent behavior of the defendants, but it doesn't, so you lose.
Yes, Your Honor.
But did it address Nurse Burns' qualifications as to the standard of care that she actually opined on?
That's exactly the point, Your Honor. The statute, 766-204, doesn't require that you disclose when you are disqualified. That is, when you fail to have certain qualifications. It goes to your opinion.
What if the jury rejects the opinion? You got to disclose that also?
Your Honor, in that case, that's your opinion hasn't been disqualified.
Why not? The jury, you went to trial with this expert. The jury found for the other side. Why isn't that disqualification?
Because in a trial, Your Honor, the jury makes a decision that after the gatekeeper decides that both witnesses are qualified and both have given legally competent opinions, they choose between those two. They don't disqualify one and qualify the other. In fact, Your Honor, I would suggest to you that Respondent suggests that the disqualification only counts if it's been a disqualification in Florida under the pre-suit statute. So under Your Honor's analysis, using Respondent's reasoning, if a witness testified at trial, lied under oath, the trial judge found the witness lied under oath and disqualified and struck that witness's testimony, that witness would never have to disclose that in Florida under Respondent's analysis.
Let me get back, because I want to dispute something you said, and I pulled the statute even though I had it right in front of me. Back on this ability of nurses to diagnose, you suggested in response to my question that Nurse Byrne is not somehow subject to the Florida definition of practice of professional nursing. I want to sort of challenge you on that and see if you'll concede that she is subject to that definition.
I believe she is subject to the definition.
That definition allows these folks to do certain acts, including diagnosis.
Your Honor, respectfully,
Right?
it's the observation assessment nursing diagnosis. Nursing diagnosis is not the same as a medical diagnosis. Medical diagnosis is based on your symptoms. You have X disease. A nursing diagnosis is a term of art, and it means specifically that you have an abnormality in your level of pain, an abnormality in your level of comfort, various other abnormalities. If you look at 464.003, D, advanced or specialized nursing practice, that's, I think, where Your Honor is seizing on the language that the Respondent cited about medical diagnosis.
Whatever they say, I'm going to limit it to 3A. I think you're right on that.
Your Honor, I'd like to move to the last point, which is that the trial court erred also in finding that Nurse Byrne met the requirements to opine even on negligence where there was a failure, a claimant's failure to meet his burden to demonstrate that she was duly and regularly engaged in the practice of nursing.
Okay, what is your definition of the practice of nursing, and where is that found?
Your Honor, the practice of nursing is the clinical practice. That is the provision of patient care.
Okay, but that's the definition that you've come up with. But is there some Can you point us to some legal text, a statute, or anything that would actually define the practice of nursing?
Well, Your Honor, it's clearly different from teaching, because the legislature, when it redrafted the statutes in 2003, and we all remember the elaborate pains that the legislature took in redrafting that enormous statute, the legislature said in Section 766-1025C that to have sufficient knowledge, you must have devoted substantial professional time to either, one, the practice of nursing, number two, the teaching of nursing, and number three, the research in nursing. So the suggestion by respondent that teaching is a subset of practice is belied by the legislature's drafting of 766-102.
It seems like that completely supports what the respondent said.
Your Honor, if practice and teaching were synonymous, the legislature would not have used both terms.
How does Chapter 464, assuming that that's relevant here, how does Florida define the practice of nursing?
For purposes of Chapter 464, it defines practice of professional nursing as is in 464-003. But, Your Honor,
does that include teaching?
It includes the instruction of personnel, Your Honor. Personnel are employees of hospitals. To suggest that personnel are unlicensed nursing students would be akin to suggesting that a law professor who places an unlicensed law student in a law firm and from time to time supervises and instructs him is practicing law through his unlicensed law student. Neither the student nor the professor are practicing law.
Counsel, I'm concerned that your argument here, which really is, if you'll allow me to characterize it, and you can disagree, I think your argument is that 766.202 sub 6 trumps the more specific delineation in 766.102 sub 5. Because 766.202 sub 6 talks about duly and regularly engaged, and that is a phrase often repeated in your petition. I'm suggesting to you that you wouldn't have won the Oken case if that was the case, because the court spent the entire time in Oken analyzing 5A and not 2026.
Your Honor, in Oken there was never any dispute that the doctor was duly and regularly engaged in the practice of his profession. He was an emergency medicine physician. And so 766.2026 says you must meet two requirements. In fact, the second district just held 2 months ago that you must meet both. That's in the Hunt case. You must be duly and regularly engaged, and you must meet the requirements of 766.1025. In Oken, the Dr. Foster, met the requirements of 766.202, the duly and regularly engaged requirement, but there was no demonstration that he could meet the requirements of 766.102. That's why the Oken case focuses on that.
And I want to make sure I understand that correctly. So it's your contention that under 766.202, a medical expert, an expert witness is a subset, is part of the definition of what a medical expert is under that statutory provision.
Under 766.2026, to be a medical expert, you must be duly and regularly engaged in the practice of your profession, and previously it was an or, Your Honor. Now it's an and you must meet the requirements, the appropriate requirement within 766.102. And of course, as Your Honors know, there are subsections that relate some to doctors, some to specialists, some to nurses, some to others, but you must meet both.
It's your testimony. It's your position then, and I'm interested. I'm having a hard time, harder than either of y'all, reconciling 202 and 102.5, to tell you the truth. But it would be your position that the guy who won the Nobel Prize in Medicine, who the University of Florida has snagged for their very fine medical school over there in Gainesville, and he was giving up his clinical practice 10 years ago in order to supervise 3 and 4 M's and do grand rounds with them once a week, but is not named on the chart for patient care. He's not eligible to testify as to the standard of care.
No, Your Honor. Residents are licensed physicians.
I'm not talking about a resident. I'm talking about a medical school professor who is not a resident.
But you said he rounds with residents.
No, I said with 3 and 4 M's is what I said. He does grand rounds with them maybe once or twice a month to observe patients, but does not do, his name is not on the chart. That's my hypothetical. He is not qualified to opine in these cases.
Your Honor, I would suggest that in that case, he is duly and regularly engaged in the practice because he is rounding and he is providing patient care.
This lady was rounding also.
She wasn't providing patient care, Your Honor, by her own testimony, which was before the trial court. I see that my time is almost expired. I apologize.
We'll give you some time because I've been throwing them at you.
Well, then I apologize, and if I cut your Honor off, I apologize. Thank you all.
Brian, may it please the Court, Brian Gowdy of Mills, Creed & Gowdy on behalf of the respondent. I'm going to jump to the last thing that Judge Kahn was talking about, which is the duly and irregularly engaged issue. And I agree, it is difficult to read these statutes. And I'm going to give it my best go here to try to explain what the legislature was doing. Before 2003, if you look at the pre-2003 version of 766.2026, which back then was subsection 5, there were two alternative ways to qualify as an expert. One was to show you were duly, regularly engaged in the practice and had a college degree, or you could just show special skill and knowledge. The legislature didn't like that second method, special skill and knowledge. You didn't even have to have a college degree. You didn't have to have a license. They wiped that off. They took that out of the statute. They left the phrase, though, in there, duly and regularly engaged. And they added some more requirements. They said you have to not only be duly and regularly engaged, you have to practice in the same field as the defendant. And they said, how are we going to, and they used the words devoted professional time, which I suggest is synonymous with practicing. And they said, now how are you going to show, Mr. Expert or Miss Expert, that you've devoted professional time? They set specific periods, 3 or 5 years, depending on the specialty, and they set specific methods. And there was 3 specific methods. One was active practice, the other was clinical, and the other was instructional. Those are all incorporated into the definition of medical expert. And so what I suggest what the legislature did was they wiped out the special skill requirement, they kept intact the duly and regularly engaged requirement, and they expanded on that and made it more stringent and said you have to be in the same field, and they gave us specific guidelines as to how you show you've devoted professional time or duly and actively engaged in practice. And what the petitioner is suggesting is that of the 3 methods that you can show this, the language they kept in actually guts the latter 2, clinical and instructional. And that the only way you can show that you are duly and regularly engaged is active. And I heard him, I think this morning, concede clinical maybe too, but not instructional for some reason. And I would suggest that if that was the intent of the legislature, then they never needed to write all those detailed requirements in 766.102 subsection 5. And that I don't think was the intent.
Does each of the, I'm looking at it, but I'm lost. Does each of the subsections of sub 5 have that?
They each, what you'll see is there's A, B, and C and, under subsection 5. For this case, we're dealing with C because it's a nurse. I believe, I don't have the statute in front of me right now, but I believe A is for general practitioners, and B is for specialists.
A is, I think A is for specialists.
Okay, but each of them, whichever one we're dealing with, they each have, the wording's a little slightly different under each, but they each have active, clinical, and instructional. I'm looking specifically at C because that's what's at issue in this case. I don't think anyone disputes it, and that's what I have in front of me. I couldn't bring the whole statute up here, but and it's clear that that's how they. It says in the statute that you devote professional time during the 3 years immediately preceding, and it places an emphasis. What it used to be, recall, was that you could have a pediatrician come in and testify about a heart surgeon's negligence. And the legislature said, no, no, no. We're going to make it be the same field. And we're going to tell you what the same field is. Same profession, actually. That's the words they use. So to suggest that the active and duly and regularly engaged in practice doesn't isn't synonymous with these three, I think ignores how this statute came about.
Let me see if I follow you then. With reference to, I know all these subsections are confusing, but you two are very well familiar. Looking at 102, sub 5, sub C, subs 1, 2, and 3. Correct. Is it your suggestion that that is not in conflict with 2026, but simply explains 2026 or
Precisely. That it's not that the only way to plausibly read them is to say that subsection 5C under 102 puts a more refined definition on what you have under 766.202. It's not a separate and apart requirement.
I'm not sure I agree with that. I'm
Okay.
not sure I agree with that because 766.2026,
Right.
medical expert, means a person duly and regularly engaged in the practice of his or her profession,
Right.
and who meets the requirements of an expert witness set forth in 766.102. So it seems to me that those two requirements are separate, and the way I read it, it's designed to address, I think, a hypothetical or a situation that you just brought up, which is if you have a healthcare practitioner who is cardiologist, okay, he or she is duly and regularly engaged in the practice of his or her profession.
Right.
Got that. But if he or she is going to opine on the negligence or lack thereof of a doctor who is in a different area, perhaps,
A pediatrician.
then he or she must have, in addition to being duly and regularly engaged in the practice of his or her profession, must also, during the 3 years immediately preceding, have done one of these three things in the same or similar health profession. So to me, those two statutory requirements are different. Now, maybe they seem to say the same thing or mean the same thing in this particular case.
Right. I agree, and I think to say they're separate, I misspoke. They clearly could be fact patterns where you would have situations where you would meet one and not the other.
Because it doesn't make sense that the legislature would say
Right.
but then they both mean the exact same thing.
Right. And I don't mean to say they mean the exact same thing, but I guess my point is that in this fact pattern, you can't say that someone would satisfy one of those three criteria for devoted professional time under subsection 5 of section 102, and then turn around and say, aha, but you don't qualify for the active and duly and regularly engaged in the practice. And what I would suggest is that, as I think you pointed out before, there is no definition in 202 subsection 6 for duly and regularly engaged in the practice.
So where would the court look for that?
Well, I mean, the petitioner's position is that it has to be active, or this morning I heard perhaps clinical, and that it could never be instructional. And I would suggest that you could still look at subsection 5 of section 102, and you can also look at the Nurses Practices Act, and which specifically talks about supervision. The exact words are supervision and teaching of other personnel. Now, the argument I heard for the first time this morning, other than in a footnote in the reply brief, which there was some vague reference to it, is that other personnel cannot mean students. I don't understand why. Now we're starting to try to parse that word out too, to say that means only employees. I think it's clear under the Nurse Practice Act, which talks about the practice of professional nursing. It has many things listed, including nursing diagnosis. And then it says the super and teaching of other personnel in the theory and performance of any of the above acts. So I think you could look there, and I think you could look at 102.5c. And, I think the court can look at how people normally understand those words. And I would disagree with my brother on the argument that a law professor couldn't be considered somebody engaged in practice. I think professors can be. It depends what they're doing. And so I think you put all those things together, and you would find in this situation where we have a nurse who they want to criticize what she was doing, but the bottom line was she was taking students to a hospital and teaching them in the treatment of patients. And so she meets the criteria for both statutes. I'd also, just to make sure I touch on the other issues, as far as qualified to opine on causation, there was a suggestion in the reply brief that what we're saying is that anybody can opine on causation. That's not true. If you look at 203 subsection 2, it says that you have to have a verified written medical expert opinion from a medical expert as defined under 202 subsection 6. So we're back to the same provision that we just talked about. And now, as amended, you have really, I would say, three parts of that statute. One is you duly and regularly engage in practice, which we just talked about, and we would submit we satisfy. And the other two are that you have a college degree. There's no question that Nurse Byrne had a college degree. And the other is that you satisfy 102 subsection 5. They don't challenge that. So if you look at the plain definition under subsection 6 of 202, it just has those three things. And what the hospital is trying to add now is the entire body of evidence law on rules of admissibility, including, for example, this morning was cited the case from the Florida Supreme Court that is on 702 at trial dealing with the admissibility of evidence. That's not in the statute.
Let me ask just one quick question.
Yes, Your Honor.
When it comes to determining whether or not the medical expert qualifies to give an opinion, attached to the pre-suit notice, is there a separate determination on the negligence piece and a separate determination on the causation piece, or is that person just she's either an expert or she's not?
Well, what I would say, I think she's either an expert or she's not. What I would say is that the very detailed requirements set forth in 102 subsection 5 all deal with the standard of care.
Because I think both parties, at least the way I'm hearing the arguments or the way I understand the arguments, both parties have seemed to make a distinction between an opinion on negligence and an opinion on causation. And I don't understand, based on the wording of these statutes, I don't understand why there's a distinction.
Well, here's why the distinction is important. Is if you look at 102, section 102, 766.102, it's all about standard of care. And those have very detailed requirements. And that's what the Oken v. Williams case that this court decided was that. If you look at causation, there's really nothing in the statute other than it says you have to have an opinion on causation. There's nothing listed. And we're here on a cert review. And they're basically having to resort to all cases. All the cases they're relying on are where you had an evidentiary hearing and a motion in limine, or they were at trial, and there was all this evidence that came in. And they're wanting to do all of that at this very preliminary stage and get cert review, which is a very stringent standard. We're not here on a plenary appeal. We're not here on an interlocutory appeal as a matter of right. And they have to show harm that cannot be remedied on plenary appeal. They're free to go back, file their motion in limine, and get Nurse Byrne excluded if they think they can do that under the rules of evidence. That has nothing to do with Chapter 766 in the pre-suit notice. Chapter 766 just says you have to have reasonable grounds to corroborate. It doesn't say you have to prove your case at this point. The statute, the expert is reasonable grounds have to be corroborated. Nothing more. I just briefly will address the disqualified opinion argument. Judge Kahn, I think you've hit it right, the nail on the head. Just because an opinion is rejected doesn't mean it's disqualified. What I heard was that if a jury rejected it, then that wouldn't be disqualified. But if a judge rejected it, it would be. Disqualification in the law has traditionally, and by the dictionary, always meant do you have the qualifications or not to testify. It's in the fact that a judge found Nurse Byrne's opinion on nursing standard of care not relevant to a doctor's standard of care doesn't mean her opinion was disqualified or that she was disqualified. It means the judge found it was not relevant. It has nothing to do with her qualifications.
I'm not sure, to be honest with you, I meant to ask your opponent. I'm not sure where we're going with this, because as I read the Oken case, I think I agree with your opponent that poor old Dr. Foster's been disqualified. Yet in reality, as we all know, what happens is Dr. Foster is consulted by the plaintiff's attorney and said, look at these records, give us an opinion, which he does, and he's certainly competent to give an opinion, yet he's now been disqualified because of this intricate statutory scheme.
Well, Your Honor, I guess what we're here on, I don't want to get into the details of whether or not he was disqualified.
I'm just pointing out I don't know what it means.
Right, and I see my time's about up, so I'll leave to conclude, is that disqualified is not just any opinion that's rejected, because I think you're right. Then if you accept the petitioner's interpretation, as they've argued it in their papers, then when an expert loses a trial, his opinion's rejected by a jury, then he's disqualified. And I don't think that's a logical reading of the term disqualified or in conformity with the dictionary. Thank you.
You got 24 seconds. We'll allow you about a minute. Mr. Gowdy's pretty strict on this time.
Thank you, Your Honor. Your Honors, Nurse Byrne was never demonstrated by the claimant to be legally competent to corroborate the second element that the legislature says a party must corroborate. Not just negligence, but that negligence resulted in injury.
Let me tell you, by example, what I find odd about that argument. Maybe the right argument, but what I find that argument odd is, go back to a medical school situation, the Nobel Prize winner. But instead of my first hypothetical, this guy really is, he's going in the hospital, and you're not concerned about that. What you're concerned about here is his actual paper qualifications. His paper qualifications are that he won the Nobel Prize in medicine or anatomy and physiology or whatever. He's a faculty member at the University of Florida. He's got this big distinguished chair and everything, and he gives an opinion. Yet in reality, he's senile and can't even read a line left from right once you sit him down to voir dire. That opinion is going to be admissible, isn't it, for purposes of pre-suit?
Yes, Your Honor, it would be.
So why is it Nurse Byrne's opinion?
Because the claimant's...
I'm sorry, based on her CV. She may not be able to testify at trial, but based on her CV, why isn't that enough?
One, in 2003, the legislature swept away the distinctions between pre-suit qualifications and trial qualifications. That's what the court said, the 4th District said in Paley v. Mirage. That's what this court said in Oken. That's what the court recently said in Hunt. Number two, a nurse, except under the most extraordinary of circumstances, is not competent, legally competent, to opine on medical causation.
Then who
and the
would
case,
be? I mean, what
physician, Your Honor.
So what you're saying is
a neurologist,
that in
a
any
neurosurgeon.
case that involves negligence by a nurse, that only a physician is qualified to opine as to negligence and causation.
Or a nurse who demonstrates her special qualifications and experience in this discrete area. The case that they rely on, the Apostolico case in pre-suit, held that a nurse, to be qualified to opine on causation, has to demonstrate her special qualifications. The suggestion...
Let me tell you where I see us going, though. And we're taking where I see us going. I appreciate your argument, but where I see us going on this, if we rule in your favor, is that your learned colleagues in the defense bar are going to say, aha, the standard to be applied here, we can't know whether she's qualified to give the pre-suit until after we've done discovery and found out whether she'll qualify under 90.702. And, Your Honor, if you won't let her testify under 90.702, then you need to go back and strike the pre-suit. Isn't that what the next argument's going to be?
No, Your Honor, because I think there are cases, in fact, that stand for the proposition that there's a risk of waiver. You can't sit on an alleged failure to comply with pre-suit.
No. I'm talking about in the pre-suit stage, just where this case is. If we adopt your argument, why wouldn't the next case come along and say, hey, she's not a nurse, she's a doctor, she's a specialist, but we want to examine her to show that she's really not an expert?
Because, Your Honor, at this stage, while the standard is the same, that is, there must be a demonstration, there's a demonstration based on limited evidence, which is her affidavit and her notice and her CV. Her CV fails to demonstrate anything that would meet the claimant's burden to demonstrate by facts that she is legally competent to testify to corroborate the issue of medical causation. She is a nurse, a well-trained nurse, a well-qualified nurse, but not a
If they
nurse.
brought in a pathologist, 4-year medical degree, residency, board certified in pathology under sub C, who says, oh, causation.
And if that pathologist had on his CV,
He's a pathologist.
well,
He
Your Honor,
makes the slides all day.
and
He's a doctor.
he also went through medical school and went through internal medicine training, where he would have specialized training and experience in neurologic conditions. Now, perhaps he might not meet, if he wanted to opine on standard of care, that would be different. But on causation, presumably on the face of that affidavit, as you've described it, he would be competent, as would a nurse who had specialized training. It is not our position that a nurse may never opine on causation. It is our position, and the position of the case that respondent relies on, the Apostolico case, only that you must demonstrate their competence, even in pre-suit. Apostolico is a pre-suit case.
So it's not enough for, it's not enough for a nurse who, I don't, just using the facts of this case, 25 plus years, PhD, degrees underlying that. It's not enough for that witness to say, well, I've looked at these records, and it's my opinion that had he not languished unattended for those 2 days in July of whatever year this was, that the outcome here would have been better. That's not enough for causation in the pre-suit stage.
Based on what, Your Honor?
Based on if the nurse,
20 years of nursing,
and if the nurse had rung the bell the first day instead of the third day, the outcome would have been better.
20 years of nursing experience in providing care within the scope of professional nursing, not in the diagnosis and treatment of medical conditions. If she was a specialized nurse, came under that specialized section of 464, that would be different. If she were a medical doctor, that would be different. If she had some kind of special expertise in this discrete area, that would be different. If any of that was on her CV, remember, the claimant in this case took the position that they didn't even have to offer evidence that she was competent to opine on causation. Thank you, Your Honors.